Can green card holders travel abroad after the recent Supreme Court ruling? And should green card holders travel abroad? And what consequences can international travel create? These are the subjects we are going to discuss in this video. I have seen a lot of online information saying not to travel with a green card because of this Supreme Court decision involving people who travel internationally while criminal charges are still pending today. So I want to go over this carefully and explain in detail when it becomes risky to travel abroad as a green card holder in these circumstances. What are the consequences of this Supreme Court decision, and how might it affect permanent residents, meaning green card holders, inside the United States? I will also share some practical considerations and tips that I think may help when thinking through this issue if someone finds themselves in this situation later on too. First and foremost, welcome back to the channel. I'm an attorney who helps foreign nationals navigate the U.S. legal system. I've spent many years in this field and regularly advise permanent residents who live overseas or travel abroad, often on re-entry questions and on how to navigate travel while maintaining permanent resident status, especially when an arrest or other criminal issue could complicate that travel, in many common cases like this one today. So I have a bit of experience with the topic we are discussing today. If you enjoy the video, please tap the like button so I know you appreciate this subject a lot. It will encourage me to make more videos like this one, and subscribe to the channel if you want updates whenever I publish a new video. With that said, let us move straight into today's topic, which is international travel on a green card after the recent Supreme Court ruling here today. The reason this Supreme Court case, often called Blanche v. is such a major issue is that the court said a permanent resident returning to the United States who has pending criminal charges, or who has been convicted of a crime, can far more easily be treated as someone seeking admission, rather than as an already admitted permanent resident under this framework today. The reason that matters is that if someone is only seeking admission, meaning someone who is essentially knocking on the door and asking to be allowed into the country, it becomes easier for a customs officer to start deportation proceedings against that person for the government in immigration court. That can make it easier for the government to remove permanent residents. I will go through all of this in much greater detail in this video. Before we move any further, I want to explain the difference between being an applicant for admission and being already admitted, because being treated one way or the other has major consequences here. And to restate that point, the customs officer decides how to admit someone into the country, either as an applicant for admission or as already admitted. Now, if someone is treated as already admitted, they are a permanent resident, right? Coming in as a permanent resident. They have entered the country that way already too. In those situations, if the government wants to start removal proceedings, those proceedings are called deportation proceedings in court for now. In deportation proceedings, the government carries a high burden to prove that the person committed a particular crime and that, because of it, the person should be removed ultimately. Not only is there a higher burden of proof to demonstrate and establish that there was a conviction and that it rose to the level requiring removal under immigration law in practice. In addition, the list of offenses that can make someone deportable is much narrower in these cases overall here. For example, if a person is convicted of a CINT, even a single one, it usually must have occurred within 5 years of getting permanent resident status for removal to be possible under immigration rules in many cases after that point at least. So it is essentially a narrower removal process in which the government still carries the greater burden of proof. That means it is easier for the immigrant, meaning the permanent resident, to defend themselves in immigration court. Now, if someone is treated as an applicant for admission, the immigration court case becomes an inadmissibility case because the individual, the foreign national and green card holder, is treated as if he or she is applying for admission into the United States, essentially like knocking on the door and trying to get in under this framework for CBP review at the border now. Now, for those cases, people have different rights because they are asking to be let in, not someone already admitted a permanent resident. And that means, in immigration court, instead of the government having the burden of proof to show that the person should be removed, the applicant has to prove and carry the burden of showing that he or she should be allowed into the country at that stage there. And not only that, it is a much broader set of criminal offenses that can make someone inadmissible. For example, a single CINT that happened at any time, anywhere in the world, depending on severity, could make someone inadmissible there. So, in practical terms, if someone is an applicant for admission, it becomes easier to argue that the person should be removed, and harder for the permanent resident in that position to defend themselves in immigration court there. That is exactly what happened to Mr. Lawo in this Supreme Court case, after he was arrested and charged with a counterfeiting offense in New Jersey. He later traveled internationally, and when he returned, the customs officers, meaning CBP, admitted him into the United States as an applicant for admission, rather than as someone already admitted during entry processing that day. He later pleaded guilty to that offense, and the government immediately began removal proceedings, which led to an order of removal much more easily because those proceedings were inadmissibility proceedings, and the offense to which he pleaded guilty was enough to make someone inadmissible in the United States under immigration law in this context for CBP review. The way the case reached the Supreme Court was that Mr. Lawo challenged being admitted into the United States as an applicant for admission, instead of as a permanent resident already admitted during entry review. Mr. Lawo's argument was that the CBP officers, when admitting him into the country, needed clear and convincing proof that he had committed an offense, rather than relying on a pending charge alone in practice. And that is what the Supreme Court rejected here. Put simply, the Supreme Court said that customs officers do not need clear and convincing evidence that an offense was committed, which usually means a conviction and a final disposition in court. Instead, customs officers have the authority to decide on the spot how to admit someone into the United States as an applicant for admission, or as already admitted based on what they see. So even if there is only a pending charge out there, the customs officer can make that determination for entry purposes. There is no need for a conviction. So even though someone has not yet been found guilty in criminal court, which means they are innocent, right? Because you are innocent until proven guilty, a customs officer could still potentially admit them as an applicant for admission on re-entry. And that is why this case is such a big deal for everyone here. So this Supreme Court decision gives customs officers a huge amount of authority to decide how they admit permanent residents, which can have serious consequences for those people today. That is why this case is such a big deal. And there are some very important takeaways that anyone in this situation should keep in mind as they move forward carefully. First, if someone is a permanent resident and is being charged with a crime before traveling internationally, they should definitely consult an experienced immigration attorney to evaluate whether there is a risk that, upon re-entry, they could be treated as someone applying for admission, because that can lead to serious consequences for them overall in practice today. In Mr. Lawo's case, I can tell you from experience that I regularly speak with people about travel plans, re-entry, and how to navigate travel, whether it is as a permanent resident or on a visa, when questions come up often for them. A qualified immigration attorney should be able to advise you on this and help you navigate it carefully. But without advice or research, traveling blindly while you have a pending charge, even though you are still innocent in the criminal case, is no longer necessarily safe for travel today. It may still be safe in some situations where the charge is very minor, but even then one has to be careful because, at the end of the day, a lot of different crimes are treated as CINTs by law. There is such a broad net at that stage that a customs officer, under this new decision, could very easily treat someone as an applicant for admission during the re-entry review process itself today. The second major takeaway concerns the criminal case itself. So while it is absolutely critical to hire a qualified criminal defense attorney for any criminal case, it is also important to evaluate the immigration consequences of that criminal matter before making any plea decisions. This is especially true when a plea deal is on the table, or when the person plans to plead guilty to a particular offense. Because criminal defense attorneys and their clients often ask us to evaluate whether pleading to those charges would create immigration consequences, and those consequences can affect travel, status, and future options after the criminal case ends for many people long-term in practice there later on. And it is very common for the criminal court case to move much faster if the person simply pleads guilty, and the punishment on the criminal side may be very minor, such as a fine, or no jail time at all sometimes. For example, a fine or, no significant jail time or anything like that in practice. People are often quick to plead guilty because they are happy not to face more serious punishment on the criminal side in many cases. But depending on the offense, regardless of the sentence the person receives when convicted, it could still lead to serious immigration consequences for them later on re-entry. Also keep in mind that an admission of guilt in criminal court, even without a conviction, can still create immigration problems in some cases. The bottom line is that if you find yourself in this situation, make sure your criminal defense case also considers the immigration consequences of that defense strategy before you decide. If someone has been convicted of a crime, meaning you have been convicted of a crime, be very careful about international travel as a permanent resident in the future, long-term as well. And because many people who have already been convicted of crimes cannot apply to become naturalized U.S. citizens, many people remain permanent residents for a very long time indeed sometimes. That can mean difficulty traveling internationally for the long term. This is why, again, people should speak with someone who can evaluate their specific case and convictions to see whether international travel is risky or not. Because after this decision, even a conviction, especially any CINT, could create a major issue for international travel when returning to the country there later. Now, another important point is that people who have never been arrested or charged with crimes should not be affected by this decision, because there would be no reason for CBP officers not to treat them as already admitted permanent residents when entering the country again. This issue generally comes up if Customs sees some kind of criminal case in the file. So while yes, this decision is scary and gives Customs officers a lot more leeway to make this call, they still need some kind of basis for the determination they make when they review the facts at entry under this authority in practice, on the spot there today. Generally, I do not think Customs officers would do this unless they saw some sort of criminal case and violation that would lead them to make that determination at entry. I have seen a lot of videos online saying that permanent residents should not travel internationally, but I do not think that is necessarily true at all. If anyone is worried, again, speak with a qualified immigration attorney. Another part of this situation is when someone was charged with a crime, but the charge was dismissed or withdrawn and treated as if it never happened in the end, really. It was essentially an incorrect charge against a person because of some misunderstanding or something similar. Now, in those cases again, because there is no pending case and no conviction, Customs generally should not create this issue because there is no basis for it, right? No conviction and no pending criminal case, so why would Customs do that? However, if there is a criminal record under this decision and that record shows up, Customs officers could dig deeper, ask more questions, and send someone to secondary inspection for review there later on. So if I were in that situation, I would definitely carry proof of that dismissal and the fact that the case went away, just in case during international travel, and keep it handy at entry too. But instead of just listening to me on an informational video here, if you find yourself in these situations, please speak with a qualified immigration attorney before you travel internationally, so that you can be prepared on what to do, because this decision does in fact change a permanent resident's rights upon entry into the country overall today. And if there has been any criminal matter in the past, this decision does in fact complicate re-entry quite. Anyway, I do not want to make this video long. If anyone has questions, comments, or anything similar, please post them below and I will do my best to record more videos like this for you all. Again, if you like the content, please like the video and subscribe to the channel and you will get notifications whenever I publish a new video. Thank you for watching.